Hi everyone, my name is Rachel Newman, and today I'll be presenting on guardianship and forensic psychology. This topic comes from Melton et al., 2017, and I'll be focusing on how courts handle guardianship, the role of psychologists, in addition to some challenges and alternatives. For our introduction, guardianship is when the court appoints someone to make decisions for a person that's found legally incapacitated. This often will involve elderly individuals, minors, or people with disabilities. The purpose of guardianship is protection, making sure vulnerable individuals are safe. But it creates tension, as how do we protect people without stripping away their autonomy and their dignity? Melton et al. Emphasizes that competence should be seen as task-specific, meaning that people may handle some decisions, but not others, and we shouldn't automatically assume a broad loss of rights. This can be seen on page 355 to 356. Moving on to legal standards, it's hard because courts must decide whether someone lacks the capacity to manage finances, make medical decisions, or provide for basic needs. The standard is clear and convincing evidence because guardianship removes a wide range of civil rights. Some states, however, still have vague definitions, which can lead to arbitrary decisions, such as the Utah Supreme Court case in Boyer ruled that statutes must clearly require proof that a person cannot care for their safety or basic needs. Otherwise, they're unconstitutionally vague. This is on page 359 to 360. This shows how the law struggles very often to balance autonomy and protection. Moving on to the psychologist's role, psychologists play a crucial role in these cases. They don't just diagnose, they conduct functional evaluations, and that means assessing whether a person can manage money, handle daily living activities, and follow medical advice. They may also look at vulnerability to exploitation, too. Importantly, Melton et al. Highlights that functional evidence is often missing, which pushes judges toward overly broad guardianships. By giving courts detailed evaluations, psychologists can help promote limited, more tailored guardianships to the individual. And this is on page 361 to 362. Moving on to ethical and practical challenges, guardianship can be extremely controversial. One challenge is over-restriction, when someone loses more independence than necessary. Abuse is another issue, where guardians misuse funds or power. Cultural factors also matter, since ideas about independence vary across communities. That's why the least restrictive alternative principle is so important. Courts are encouraged to consider limited guardianships or alternatives like advanced directives before taking away full rights. And this is on page 358 to 359, as well as 362 to 363. Now to look at the case example of Mr. Galvin. Melton et al. Included the case of Mr. Galvin, who's an older man with medical and psychiatric issues. He showed signs of confusion, hallucinations, and delusions, such as believing he invented the snowmobile. But he has also handled some financial matters and daily tasks, and therefore the court had to decide whether he truly needed a guardian, and if so, whether it should cover his estate, his person, or both. This is on page 356 to 357. This case illustrates the complexity as people can have real impairments while still functioning in some areas, which is why limited guardianship should be on the table. Moving on to reforms and alternatives. Reforms since the 1980s have aimed to make guardianship more fair to the individual. Courts are also supposed to consider alternatives to plenary guardianship and encourage the person to attend hearings. Alternatives can include advanced directives, supported decision-making, and adult protective services. These options preserve more autonomy and reduce overreach, but unfortunately, they're still rarely used in practice. Supported decision-making, for example, allows individuals to remain actively involved even if they can't meet traditional standards of capacity. And this is seen on page 358 to 364. For my media source, I wanted to find something that I could connect guardianship to real-world practice. So I found a YouTube video called A Guide to Guardianship, and it explains the legal and psychological aspects of guardianship, walks through the responsibilities of guardians, and shows how the process can impact an individual's autonomy. This video reinforces what Melton et al. Describes, that while guardianship is designed for protection, it also carries risks if not carefully tailored or overseen. It highlights why good evaluations and safeguards are so important. Moving on to the discussion question, after reading through the book and everything we've learned so far, I wonder how should courts go about balancing protecting vulnerable individuals while respecting their autonomy when they're deciding on guardianship cases. I feel like there's no easy answer, and that's what makes this such an important issue in forensic psychology. To wrap this presentation up, guardianship is one of the oldest aspects of the mental health law, and it's still evolving. Courts rely heavily on psychologists to provide capacity evaluations, which can prevent overly broad restrictions. Ethically, we should always aim for the least restrictive alternative. My references are Melton et al. 2017 and the YouTube video, A Guide to Guardianship.